Good morning. I am Assistant Inspector Nicholas Navarez, and I'll be going over the Ellis Act. What is the Ellis Act? It was established in 1985. The Ellis Act is a provision in California law that provides landlords in California with a legal way to go out of the rental market business. The Ellis Act was adopted by the California legislature in 1985 after the California Supreme Court decision in the case of Nash versus City of Santa Monica. The California Supreme Court held that municipalities could prevent landlords from evicting their tenants to go out of business in order to withdraw their properties from the rental market. In Los Angeles, applies rent control provisions to units built on the same property up to 5 years later. Los Angeles Municipal Code Section 151.09.8.10 and 151.22 through 151.28. A landlord may recover possession of a rental unit under either one of the following circumstances: to demolish the rental unit or to remove the rental unit permanently from rental housing use. How to determine if a property has been withdrawn under the Ellis Act. You would open up ZMIS, and on ZMIS you would search up an APN. After searching up the APN, you would click down on the housing section on the housing tab, and where it's highlighted, it will tell you whether a property has been withdrawn under the Ellis Act or not. What to expect as a tenant. Letter of introduction from Los Angeles Housing and Community Investment Department. The letter of introduction advises the tenant that an application of intent to evict has been filed by the landlord. It will indicate the following: the type of eviction, case number, the assigned analyst's name and contact information, and contact information to city's relocation consultant. The tenant's case will be referred to city's relocation consultant, which will contact the tenant to conduct an over-the-phone interview and provide the tenant with transportation and support during relocation. The over-the-phone interview determines the following: household status, qualified or eligible. A qualified tenant is any tenant who, on the date of service of the written notice of termination, is 62 years of age or older, handicapped as defined in Title 42 of the United States Code Section 243, or who has one or more dependent children as determined for federal income tax purposes. Eligible tenant. Unless a tenant is a qualified tenant, as explained earlier, the tenant is an eligible tenant and is entitled to receive a relocation assistance amount that depends on length of the time and unit and income. The interview also determines the amount of relocation fees a tenant may be entitled to, and replacement unit listings tailored to the needs and transportation services. Tenants' rights and responsibilities. Tenants are entitled to a 120-day notice of eviction. Property owners are responsible for providing the tenant with the completed notice to tenant of pending withdrawal and a blank notice of interest in renewing tenancy. The notice of eviction and the form should be provided within 5 days of the property owner's filing of the notice of intent with HCIDLA. Tenants who are 62 years of age or disabled and have resided in his or her rental unit for at least 1 year may be entitled to a 1-year extension from the date the landlord delivered the notice of intent to withdraw to HCIDLA. Relocation assistance. Tenants may be entitled to relocation assistance fees. The city's relocation consultant determines the amount of fees a tenant is entitled to. Otherwise, the determination will be based on the information given by the landlord. Tenants have a right to appeal the determination within 15 days of the issuance. Appeals must be received by HCIDLA with the completed appeal form and the $200 filing fee made payable to the City of Los Angeles. Low income exemption waiver. The applicant's annual household earnings must be no more than 50% of the median income in the Los Angeles area. Landlord shall provide relocation assistance payment within 15 days of service of the eviction notice. Payment can be made directly to the tenant or through an escrow account. Tenants interested in returning to the rental unit should it become available. Tenants shall advise the landlord in writing within 30 days of displacement that they are interested in considering an offer to renew the tenancy should the unit become available. During the 2-year period of eligibility, notify the landlord and the department of a change of address. The landlord shall inform the tenant via certified mail if the unit becomes available. Notice from the landlord shall describe the terms of the offer. Tenants have 30 days to respond to the offer. Landlords must offer accommodations at the lawful rent in effect at the time the notice of intent to withdraw the accommodations was filed with HCID LA, as well as annual adjustments available per LAMC 151.06. Procedures for withdrawing units from the rental housing market. Call to schedule an appointment for application submittal at 213-808-8537. Complete and record the memorandum summarizing non-confidential provisions of a notice of intent to withdraw units from rental housing use with the county recorder, and obtain a copy showing the recordation stamp for filing with HCID LA. Submit the following documents at the time of the appointment. Copy of the non-confidential memorandum, complete notice of intent to withdraw units from rental housing use, copy of grant deed, copy of articles of incorporation or limited partnership if owner is not a natural person, copy of the notice to tenant of pending withdrawal, copy of notice terminating tenancy to be served to tenants as required by California state law. For demolition or conversion of structure, copy of LADBS notice of intent to demolish and clearance summary worksheet, only if units are all vacant. Administrative fees. Withdrawal process continued. The application must be submitted in person and requires an appointment. Call 213-808-8537 for an appointment at the HCID LA public counter located at 1200 West 7th Street, First floor, Los Angeles, California, 90017. Serve your tenant with a 120-day notice terminating their tenancy in accordance with the applicable requirements of California state law. Notify your tenants of the withdrawal of their rental units and their rights under state and city laws by serving each household to be displaced with a completed notice to tenant of pending withdrawal and a blank notice of interest in renewing tenancy. This step must take place within 5 days of your filing of the notice of intent with HCID LA. However, it is recommended to serve the tenant on the day of the filing the notice of intent to withdraw. Pay relocation assistance within 15 days of service to tenants who will be evicted. This payment can be made either directly to the tenant or through an escrow account. Inform HCID LA of any tenant claims for entitlement to extended tenancy by completing a notice to city of claims for extended tenancy. Notify tenants in situations where you elect to extend the date of withdrawal up to a year for households not otherwise entitled to such an extension. Notify HCID LA in situations where you elect to extend the date of withdrawal up to a year for households not otherwise entitled to such an extension by filing a notice to city of extended dates of withdrawal. The next few slides are some of the required documents that landlords will bring with them when they arrive at their appointment. This is the non-confidential memorandum. On it, you would include the name of property owners, the legal description of property being withdrawn from rent or lease, common description, street address of property being withdrawn from rent or lease, and all owners must sign and all signatures must be notarized. Notice of intent to withdraw units from rental housing use. On this form, you would fill out the property information for units to be withdrawn from rental housing use, owner information, the future use of withdrawn accommodations. Also gives you a checklist of the required documentation to bring with you on your appointment. The landlord would also fill out the tenant information for each of his tenants. Notice to tenant of pending withdrawal. This form notifies the tenant of his right to return to rental unit at controlled rent, right to damages if your landlord re-rents within 2 years, right to extended tenancy for senior or disabled tenants, and right to relocation assistance payment. Notice of interest in renewing tenancy. This form declares that I, as a tenant, wish to be contacted by the landlord in the event that the accommodations at the address where I am/was a tenant are again offered for rent or lease within 10 years from the date on which they are withdrawn from rent or lease. I can be contacted at or through the following addresses and wish any offer to renew the tenancy be sent to me as follows. It's important to note that the notice must be given to the landlord no later than 30 days after the date the tenant has vacated the property that is being withdrawn. Notice to City of Claims for Extended Tenancy. Here on this form you would provide all rental units where a tenant claimed an entitlement for extended tenancy. Notice to City of Extended Dates of Withdrawal. On this form you would provide information for all rental units where the date of withdrawal has been extended from the date provided in the Notice of Intent to Withdraw Units from Rental Housing Use previously filed for this property. Ellis Act evictions in City of Los Angeles. The Ellis Act was originally designed to protect small mom-and-pop landlords who could no longer tend to their rental property. Tenant groups from LA claimed that landlords abused the Ellis Act to bypass rent control and cash in during peak housing market periods. Large developers acquire rent control housing, destroy it, evict tenants, and replace the existing housing with high-priced luxury housing. Between the years 2001 and 2019, over 26,500 units, over 3% of the total rent-controlled housing stock, were taken off the market using the Ellis Act. That's it for my presentation. Thank you for listening.